You just got in a crash, and now the insurance adjuster is calling, asking questions you're not sure how to answer. You're sitting there thinking, if I say the wrong thing, could I screw this whole thing up? And the truth is, yeah, you can. What you say in these early conversations can absolutely impact your ability to recover damages later. I'm Doug Burnetti, a personal injury attorney who's been practicing for over 30 years handling cases just like your injury case. In this video, I'll walk you through exactly what to say and what not to say when the adjuster calls so you don't put your claim at risk before it's even started. Number 1, why insurance adjusters call so quickly after a car accident in Florida. Let's talk about what actually happens after a car accident here in Florida. You're shaken up, you're dealing with the damage, and maybe you're worried about injuries. Suddenly, your phone rings. It's an insurance adjuster, sometimes from your company, sometimes from the other driver's company. They waste no time. But why? Insurance adjusters aren't just being friendly. Their job is to protect the company's bottom line. They want to collect details from you before you've had a chance to speak with a lawyer, see all your doctors, or even process what happened. The sooner they reach you, the more likely you are to say something that might hurt your claim down the line. It's not paranoia. It's reality. The insurance adjusters have a conflict of interest with you, even if it's your own insurance company. You might hear things like, we just need your side of the story, or this will help us wrap things up quickly for you. But what they're really doing is looking for information they can use to minimize your payout. And remember, your words can and will be used against you, even by your own insurer, if you end up with a big medical bill. So when that adjuster calls, take a breath. You do have to cooperate with your insurance company under Florida law, but you don't have to rush into it. You have the right to control what you say and what you don't say, and that's what this video is going to help you do. Number 2, the key questions adjusters always ask and what's really behind them. Let's break down the usual questions you'll hear from an insurance adjuster after a car incident, and I'll tell you what they're really fishing for. Number 1, can you give me a recorded statement about what happened? This is a big one. You are not required to give a recorded statement to the other driver's insurance company. You may be contractually obligated to give a statement to your own insurer, but it's almost never a good idea to do it without speaking to a lawyer first. Adjusters love getting you on record as quickly as possible. They may act like it's just a formality, but once your words are recorded, it's very hard to walk them back. Maybe you're still rattled or forget a detail. It can come back to haunt you later. Here's a safe answer. I'd like to wait until I've had time to collect my thoughts. Can I get back to you with my statement in writing? This puts you in the driver's seat and gives you time to talk to an attorney. Number 2, were you injured or how are you feeling? It might sound like a small talk, but it's not. Many injuries don't show up for hours or days. If you say, I'm fine, or no injuries, and later develop symptoms, the insurance company may claim you're lying or exaggerating. Your best move, be honest, but be careful. You can say, I'm still being evaluated. I don't know the full extent of my injuries yet. This is true, and it keeps your options open as your recovery unfolds. Number 3, do you know what caused the accident, or were you at fault in any way? Adjusters are always on the lookout for statements that can be twisted into an admission of fault. Florida uses a comparative negligence rule, and other states use different rules. But in Florida, that means that even if you're found only partly at fault, your compensation can be reduced in proportion to your responsibility. In fact, in Florida, if you're found 51% at fault or greater, you will get 0 from a jury or from a judge. Never guess or admit fault. If you're not sure, say, I'm not sure exactly what happened. I'm still trying to process everything. Let the evidence and your lawyer do the talking. Number 4, can you describe the damage to your vehicle? That's a common question, and it seems harmless, but it can be used to downplay your injuries. Adjusters may argue that minor car damage means minor injuries, even though that's not always true. People can have serious injuries in low-speed crashes. Just stick to the facts. Say, there is damage to whatever area of my vehicle, but I'm not an expert in vehicle repair. And trust me, that is so true. I've seen people bring in cars and they think, oh, it's going to be cheap, but they end up finding out, wow, there's damage under the body shell that they didn't see that ended up costing thousands and thousands of dollars. Don't make guesses about how much the repairs will cost or what caused the damage. Number 3, how to protect your rights while cooperating in Florida. You do have to cooperate with your own insurance company in Florida. It's a requirement in your policy. But that doesn't mean you have to give up your rights. Here's how to protect yourself. First, ask who you're speaking with. Always get the adjuster's name, title, the company they represent, and a callback number. I can tell you that I've had clients who have hired me after the fact, and they'd already talked to an insurance company, and they didn't even know which insurance company it was. If it's the other driver's insurance, you don't have to talk to them at all. For your own company, let them know you want to be helpful, but be careful. Second, don't guess or speculate. Only share the facts you know. If you don't remember something, say so. Don't guess about speeds, times, or what the other driver was doing. For example, if they ask, how fast were you going? And you're not certain, say, I can't say exactly, but I'm certain I was going under the speed limit, if that is true. If you guess wrong, that statement could later be used against you if you don't answer it appropriately. Third, don't discuss injuries beyond immediate medical facts. If you've seen a doctor, say so. Tell them you're following medical advice. Avoid discussing your long-term prognosis or making promises about when you'll be better. Injuries can change over time, and what feels minor now might not be so minor in a few weeks. I've had people come in and say, I've got pain in my neck. It progressively got worse over the next few weeks, and then they needed full neck surgery and, in fact, a fusion with metal and place in their neck. Very, very bad situations. Fourth, ask for everything in writing. If the adjuster makes you an offer or asks you to sign anything, tell them you'd like it all in writing. Don't sign releases, authorizations, or settlement agreements without reading them carefully, and ideally, have a lawyer review them. Fifth, you can always pause the conversation. If you feel uncomfortable, you're always allowed to say, I'd like to talk to a lawyer before I continue. That's not being difficult. That's being smart. This is your claim, your recovery, and your future. Don't let the insurance company dictate that to you. Real world example, how a Florida driver protected their rights. Let me tell you a true story from my practice. A client of mine, Lisa, was rear-ended at a stoplight in Tampa. She was shaken, but she thought she was okay. So when the adjuster called her the next day, she said she felt fine. She didn't know at the time that she had a herniated disc in her neck, something her doctor only found out about 2 weeks later when the pain wouldn't go away and she had an MRI done. The adjuster used Lisa's, quote, I'm fine statement to offer her a small settlement. When Lisa came to my office, we made sure her medical records reflected the delay in symptoms, something that's common in soft tissue injuries. Because she didn't admit fault, guess about speeds, or give a recorded statement, we had some room to push back and get her a much better result. However, you have to be careful about the information you give the insurance companies. If Lisa had made guesses, admitted fault, or accepted that first offer, she could have lost thousands and then stuck with big medical bills. Special Florida laws you need to know when talking to insurance adjusters. Here in Florida, we have no-fault insurance, also called personal injury protection, or PIP. That means your own insurance company pays for your initial medical bills and lost wages, but only up to $10,000, no matter whose fault it is. But if your injuries are serious, you can still bring a claim against the at-fault driver's insurance. And believe me, it doesn't take much to rack up over $10,000 worth of medical bills. So anything over $10,000 is definitely serious. When adjusters call, they may focus on the PIP claim and try to close it quickly. But don't let that pressure you into settling before you know the full extent of your injuries. You have up to 2 years from the date of the incident to bring a lawsuit for your injuries, and that's the statute of limitations in Florida. Don't feel rushed. Take the time to get proper medical care and advice. And here's a big one. If an adjuster asks for a blanket medical release, don't sign it. They can use that to dig through your entire medical history looking for ways to deny your claim. Only sign forms that are specific to the injuries you're claiming, and only after you understand them, and really only after you've had a lawyer look at them. That's the safest way. What to do if you're feeling pressured by an adjuster? If you feel like the adjuster is pushing you, calling you over and over, insisting you have to give a statement right away, or telling a lawyer will just take your money, take a step back. That is a tactic. They want you to settle fast, usually for less than you deserve. Here's what you can say back. I want to make sure I provide accurate information. I'll be in touch once I've had time to review everything. Or I'm still getting medical treatment and I'm not ready to discuss a settlement. Or I'd like a copy of anything you want me to sign so I can review it first. And if you're unsure, call a personal injury lawyer right away. We deal with adjusters every day. We know how they work and we know how to protect your rights. And by the way, if they tell you, oh, a lawyer's just going to take your money, then ask them about the research that indicates that people who have lawyers representing them on average get at least 3 times more than what people without lawyers get in settlements. I can tell you my own practice, we sometimes get 100 times more than what the insurance adjuster first offers. When to consider getting a lawyer involved. If you have more than minor bruises and scrapes, especially if you're missing work or worrying about your future health, a lawyer can help you avoid costly mistakes. In Florida, consultations with personal injury lawyers are usually free, and we only get paid if we recover for you. Don't let fear or pressure keep you from getting help. Remember, insurance adjusters are trained to close claims quickly and cheaply. Having a lawyer on your side is like having someone who speaks their language and can keep you from making a bad mistake or being taken advantage of. I'm telling you this as if I was talking to my wife or one of my children. You need to have a consultation with a lawyer before reaching any settlements, if possible. Your next steps. Today, you learned exactly how to answer an insurance adjuster's questions after a car incident in Florida, how to protect yourself, what to say, and how to make sure you don't give up your rights too soon. But knowing what not to do is just as important. That's why you absolutely need to watch the next video, 3 things you must not do after a car accident. In it, I'll break down the most common mistakes that can cost you thousands or ruin your case before it begins. Don't miss out. See you over there.